ready, then I'm going to call the hearing of the Code Enforcement Special Magistrate to order. It's December 12th, 2013. And before we get started, I'm just going to go over the way that this hearing will be run, just so that we're all on the same page. If you intend to testify or present any evidence before the magistrate today, if you would please fill out a form so that the clerk can keep track of who's here and who is presenting. These are evidentiary hearings, which means that both sides are permitted to present evidence in support of their positions. I haven't spoken to anyone about any of the cases unless they're returning, and that was on the record. But if your case is new, I haven't heard anything about it, so when you approach the podium to speak, make sure that you tell me everything that you want me to know. And if you do present any evidence or want to show me pictures or documents or anything like that, that becomes part of the record, so you'll have to be willing to leave that with us. The city has the burden of proof in these matters, so they will go first, present their case. If they present me with any documents or photographs or anything like that, we'll also present you with a copy of that so you can see what it is that I'm looking at. Both sides have the right to cross-examine the other side, so if you have questions that you'd like to ask of the city, or the city likewise of the respondent, that's permitted. All testimony today will be presented under oath, and these meetings are recorded electronically. But when we call your case, if you would please step to the podium and state your name clearly for the record. And then I'll be able to help walk through the process. So, and then following the presentations, I will announce my findings, and we will then reduce that to an order that will be mailed to you. Now, if there's anyone that intends to present testimony today, if you would please stand to be sworn in. Sometimes you're not sure, just in case. Do you swear or affirm that the testimony you shall give today will be the truth and nothing but the truth? Thank you. Right, and Mr. O'Rourke, I am looking at the agenda, and I think that we have counsel present. Could we take the case with counsel, try to save money? Okay. Then, is the city going to go? The city's going to present? Good morning. Are you all there? Okay.
Good morning, Your Honor. My name is Jennifer Nix. I'm an assistant city attorney for the city of Oviedo.
And
yes.
Great.
And thank you. I enjoy it very much. And I am going to be assisting with the presentation this morning. This is for the first case on the docket. It's case CE 13-001717 regarding the Fallen Forest property and business at 371 West Mitchell Hammock Road in the city limits of Oviedo here in Seminole County, Florida. This matter was continued, you may recall, from the September 5th hearing date on an Ori Tennis motion of the city, which you granted. First of all, I'd like to have entered into the record all information pertaining to this case as Composite Exhibit A, which the clerk has a copy of.
Okay, is there any objection from the other side? Okay, seeing none, it will be admitted as Composite Exhibit A.
Thank you. Thank you, Your Honor. This case is a little atypical in the sense that we've had so much back and forth as far as counsel of the city being involved as well as counsel for the respondent. So first of all, I'd like to just provide some background, if you will. Okay. And we'd also like to present to you a stipulated order for your consideration that the city and the respondent have spent a great deal of time and negotiations regarding.
Stipulations are appreciated.
Okay. And if I may approach, I'll just bring it up to you as well as give a copy to counsel for respondent, though they have a copy also already. So it might make it easier to follow along.
Are all the issues resolved, or do we
yes.
have? Okay.
Everything will be resolved. If you're okay with the stipulated order, that would be wonderful. We drafted the entirety of it together, both parties here, and
then I just wonder how much presentation, if you all agree on all of the facts and everything stipulated. I mean, I'm happy to hear anything that both sides would like to offer, but
of course, I'll try to give you the abridged version.
No, I wasn't meaning it to rush you, though.
Okay.
You're welcome to say, to tell me whatever.
Okay.
Okay. Okay.
Your Honor, respondent here is Falling Forest Products. What they have is a business which has been operating since 1997 here in Oviedo. Basically, when they began operating, and I'm sure they'll correct me if I'm wrong, but they had obtained a business tax receipt, yet hadn't necessarily gone through all the avenues that were necessary to start a business, as far as maybe if it was zoned properly or whatnot. When this was realized, a solid decade plus later, the city decided to grant them a special exception use order such that they could keep operating their business as it was. There were some conditions, and the special exception use order is before you. And you'll note the condition that there was an alleged violation of, and the reason that started with us coming before you, is that they are not to conduct any loading or unloading activities of the mulch into truck beds, basically, on the property, because it makes a big clanging noise when the mulch is dumped and the hand hits the arm, if you will, a metal noise. So that was a prohibited, they weren't to do that between 10 p.m. and 6 a.m. On or about August 19th of this year, oh, and just to back up, the special exception use order was approved by the City Council October 17th, 2011, and that is where these special conditions come from. So on or about August 19th, just of this year, which initiated this case, there was a complaint, and the police department had gone out, and apparently there was a staff person who, while they stopped once told, was conducting some kind of loading activity with the mulch in the truck. And the parties, as you will see in the stipulated order, had come to an agreement that, yes, that was a violation. It's been corrected, and everything's corrected as of today's date, but it was, in fact, a violation of the special exception use order on that day. And then basically, the best background might even be just glancing through the stipulated order. You know, we've gone back and forth several meetings between the city and respondent with Respondent's Counsel regarding how to best rectify this issue. We've met no less than 2 or 3 times with city staff and Respondent's Counsel prior to bringing the stipulated order before you today. Basically, Section 3.3b6 was one of the sections in the city's notice of violation, which was sent to Respondent on August 21st, which was an issue here because with the city alleging that there was a violation of the special exception use order condition, the Land Development Code 3.3 says, B6, says that if anything is not in compliance with that special exception use order, that it would automatically expire. Rather than the order automatically expiring, because we certainly don't want to seemingly lose due process there, the city has chosen to perceive that that language means that something has to be repeatedly in noncompliance. So while they were in noncompliance on the 19th, we're not saying that their special exception use order is expiring today or anything. However, okay, so we would just say that it repeatedly has to be in noncompliance in order to start that process where the special exception use order would in fact expire. As you will also see in number 6, respondent waives its right to a hearing in this matter, as far as we weren't going to present tons and tons of evidence today, given that we've come up with this stipulated order and the parties agree, yes, there was a violation. Future violations would be a repeat violation. But we just figured that settlement of this matter in the way that we've gone about it would kind of be the best way in this situation. Basically, the remedial action section of the stipulated order that we've presented to you You'll see that respondent has notified the Code Enforcement Division of all of their contact information. They have had all of their employees sign acknowledgement of forms of what the conditions of the special exception use order are. This stipulated order further clarifies for everyone, was kind of the point, what the conditions are, such that they absolutely know what would be in violation or what not. So you'll see farther down that, let's see, in paragraph 12 and below, there are certain things that the respondent will do to help assure compliance in the future, one of which is installation of video cameras to where they can give tape to the city if there's an allegation, instead of, they had offered to have streaming video, but we don't know that the city necessarily has the capability, and they're not going to monitor it 24 hours a day. The respondent is going to be installing a gate at a location to be determined by the city. And then you'll see subsections B, I through 1, 2, 3, 4, 5 have to do with installation of that gate in the right-of-way and making sure that everything is okay as far as the city's permitting and everything goes there. Farther down, of course, you'll see that the respondent recognizes and agrees that it's their responsibility to ensure that they're in compliance with both the special exception use order as well as the stipulated order, which clarifies that matter. And in moving forward, you know, we would just be looking to the special exception use order or the stipulated order as a determination of whether or not they're in compliance in the future if it's an issue. I lost my page here. Did you have any questions about the stipulated order?
It looks thorough.
Yes.
Certainly. And everything looks fine to me. It's the form of the order actually that I think is unique. I realize that it's a stipulated order, but my preference would be just in the future,
yes,
for whatever that's worth. I don't want to spend any more attorney's fees on changing it, but if I would prefer to have a stipulation and an order, and just have the stipulation as an exhibit and have the order adopting the stipulation, just because it's somewhat odd for me to have the parties signing the order and having both me and the parties signing the same document. But I'm not going to ask you to redo it. It looks thorough, and as long as the respondent, I'd like to hear from. And if you have anything else that you'd like to offer.
Sean, was there anything that you wanted to add? I was trying to be somewhat abridged about it, but
yeah.
But make sure that I touched on everything, of course. So
this had to take a lot of work.
It was both on and I'd like to thank the code enforcement staff and the city staff have been wonderfully helpful, and the respondent and respondents council have contributed very much to this process as well. So we're looking forward to the city is kind of getting this put to bed and everyone moving forward.
Yes.
And certainly in the future, if we have this kind of a unique situation with any matter, we will do a separate stipulation and order, of course.
And you have a signed original?
I can have them sign it right now.
Take your time.
Okay.
I'm here till the end, so.
Okay, thank you.
Thank
and
you.
Did you have any questions for me of any
No.
sort? Okay, thank you.
Would the respondent like to say anything?
My name is Allison Yurko. I'm the attorney for the respondent. I just wanted to thank the staff and especially Ms. Nix for working with us. This is the culmination of 4 months of work, and we've gone back and forth. And we've got a great product, and it's going to help his business run smoothly. It'll be respectful to the neighbors, and we really put everything under a microscope and got it done. So thank you.
They say, blessed are the stipulators.
Yes, thank you.
Thank you. Thanks for being here,
Okay.
Counselor. Okay, then just whenever there's the original, you can give that to me, and I'll sign up on it. Absolutely. Certainly. Thank you. All right. And we'll be moving on. New case? No. O'Rourke, if you have something you'd like to handle, go ahead.
Your Honor, we have two respondents here, and we'd request that we go out of order to accommodate the respondents.
Absolutely.
So if Your Honor pleases, we would do the second case on the new business
Okay.
first.
This is composite exhibit A. Okay.
Good morning. My name's Sean O'Rourke. I'm the Code Enforcement Manager for the City of Oviedo. This is case CE 13-001682 in regards to the property at 488 East Chapman Road in the city limits of Oviedo and Seminole County, Florida, for violation of the Code of Ordinances of Florida Building Code Section 105.1, permits required, and of the Land Development Code Section 3.4, development permits, work without a permit. All the statutory requirements for the notification of this hearing have been met, and the supportive documents will be entered into the record as exhibit in chronological order, and the clerk has your packet.
Okay, does the respondent have a copy of this packet? Okay. And do you have any objection to this being admitted into evidence as the city's exhibit? Okay. And it shall be admitted. City's composite exhibit A.
Your Honor, on August 14th of 2013, we received a complaint from the fire department about an outdoor kitchen and wall constructed at this location. I left a door hanger at the time. You have photographs of the structure in your packet there that shows a fairly complex outdoor kitchen being built and a brick wall behind it and then alongside. And there's some pretty good pictures that you have there of the structure. We also have a couple of maps showing this is a very large lot with quite a bit of room in the back. So I left a door hanger, but there was no door to get to. It was left on the garage door. I was a little concerned about the weather. So 2 days later, on August 16th, we went ahead and sent a courtesy letter to the owner of record outlining the code violations. I did speak to the property owner after that, discuss with him the fact that he would need to get with the building official. There were going to be setback issues that he would have to deal with zoning about, gave him zoning numbers. And because of the potential setback issue, not knowing exactly how far or how much of a deviation would be required, that there was a possibility of having to go all the way to a development agreement. So we had that communication. We had several communications. The property owner did speak to people in zoning and building and attempted to get a permit, but as of September 6th of 2013, there had been no permit submitted. So we sent a notice of violation. That notice of violation was signed for by the property owner. The reason you have U.S. Postal Service in there is because the green card didn't come back with a date stamped on it. So we're just showing you that what date that it was received.
Glad you paid for that.
Yes, yes. We continued to have discussions with the property owner. He also had discussions with zoning and building. But again, we came to a point where we still had not received a permit. So on October 21st, we prepared a notice of hearing, affidavit of violation. We sent that via certified mail. It came back as returned to sender. So I actually went out on November 19th and I hand-delivered the notice of violation to the property owner. We have the second notice of hearing that we drafted along with the affidavit of the violation and the affidavit of hand delivery. I did speak to the property owner at length that day, and I think he's going to provide you with some testimony about our discussion on that day. But as you can see from the initial inspection till today, we are at 121 days where we're still without a permit for that particular structure that's back there. And we do still have the issue of more than likely a deviation. The question is how much of a deviation is going to be required if it stays where it is.
Because of the setback?
Yes. And a 10% deviation could be done at the staff level, 20% goes to DRC, 30% goes to PZA, more than 30% becomes a development agreement and goes to City Council. So the amount of deviation is critical in this case as determining what course of action will have to be taken. And of course, with each of those greater deviations, the cost goes up. So the applicant's got decisions to make as to whether he wants to pursue it, demolish it.
When you say that we still don't have a permit,
Correct.
has there been a permit application?
No. No.
Okay. All right, is there anything else you want to tell me?
No, ma'am.
Hear from the respondent. If you
George
would-
Cicatano.
Could you pronounce it for me?
George Cicatano.
Cicatano. Mr. Cicatano.
Yeah.
Thank you.
I did get the survey and everything, and I don't know why they drug their feet, but I was waiting on zoning a little bit for information. So then I finally got with ODG on 10/7, and I still haven't got the drawings from them.
So what you're telling me is that you hired,
Yeah, an architectural firm. Pretty much at this point, I know the drawings were done Friday, but they weren't sealed. Oh, sorry, they had to get 4 copies or something like that, and they're supposed to get sealed yesterday, but I didn't hear from them. So I'm definitely doing the steps. Obviously, it seems like it's taking longer, but I don't know how to rush people like that.
so in your discussions with the city, have they've asked you to submit architectural plans, or what is it that
Well,
they
what the
are-
city asked for was engineered drawings, and the building department. Okay. So that's the reason why I haven't done the application yet. I have it filled out, but I thought I had to do them all at the same time. The
Oh, okay,
application for a
different
permit.
departments?
I forget his name. Yeah. Okay. He said I basically need engineered drawings, so that's the step I'm at right now, getting those. And they are done, but I haven't picked them up.
And if I could ask Mr. O'Rourke, is that you, without the drawings, you don't know whether it's 10%, 20%, 30%? Is that? Right.
I'm attempting to get them.
Which avenue? Okay. The setback is 5 feet? Oh, this is the side? Okay. Well, when you last spoke to your architect, how long did they say?
I talked to them Friday. He said they're getting whatever photocopies done or however they do that. They're supposed to be sealed basically yesterday, Monday, and I never heard back from them. And I did call.
You did call?
Yeah. It was late, though, so I don't know if that's bad. That might be my bad. So.
let me ask you this, in the 120 days since code enforcement first notified you, were you continuing to build?
It was, no. It was
It was
kind of
done.
hard to find an architect to do this, you know. It's something I could afford also, let's put it
Right.
realistically. So I finally got that going, and I did do it, started on 10/7.
Okay.
I don't understand why it's taking long. I can't blame it on the holidays because it's only Thanksgiving.
Right. Okay, so how long do you think you need to?
To submit the
that-
draw, well, see, I don't know the processes after this. I mean, to submit the drawings, Friday. Zoning, I have no clue. He said that could go for months.
How long does it, after he submits the architectural documents that you need, how long is it before he gets a decision on it?
Well, the first thing that will happen is when he submits the building, they'll review the permits, see if it has everything. If it has everything that they need, they'll go ahead and give them a permit number and enter it into the system. And they'll send it to zoning for review. And again, without knowing what the percentage of the deviation is, it's impossible to tell how long it takes.
Right, but he would no longer be in violation, there would no longer be a code violation for the lack of a permit. Right. Okay,
Or
so what we're dealing with today is just how long,
Permit.
there clearly is no permit.
Right.
How long do you know, until you can submit those?
I mean, I'm hoping by Friday, but I don't know the next step on zoning, so I got to deal with both. And I'm unfamiliar with the process of both.
I'm just trying to get you to permit, so, I do think you're gonna have some time after that, but.
Yeah,
um,
the
Do you
application.
think by Friday?
The application will be with the building department by Friday. And then since it goes to zoning after,
Today's Thursday,
well,
isn't it?
okay,
today?
yeah. I am a little nervous.
You might wanna say next Friday.
Yeah.
Yeah?
Yeah, if I can do
What
that.
if, what is the, city requesting as to, time before, fine, how many, I think 10 days would be the least I would think we would want to offer for him to get his architectural things.
My only concern is it has to be a sufficient application. People come into the building department all the time and go submit an application, don't have all the materials. So the building will take the application.
Okay, then I think we might want to,
Sure that when he goes there and submits, that it's a permit that's sufficient, that nobody will take in, that they will assign a number to, and put it through the process.
well then,
Because before supply, he didn't have the materials, the correct items in the permit.
then that makes me, I think you need more time so that in case
Yeah.
I would hate for you, right, I would hate for
Yeah.
you to come in and think that you have everything and then just for them to tell you that you need something
Yeah.
else. So why don't we, I think if
I mean-
30 days, yes, so our next hearing is January 23rd, so I'm going to rule that you have until January 22nd
Okay.
to get all the paperwork in. So, my suggestion to you, I'm sure you're thinking this as well, is to get it here as quickly as you can
Sooner.
so that they can,
Because there might be things.
exactly,
Okay.
right? And the case that, well, let me let you finish. I want to make sure that you've been able to tell me everything that you.
Pretty much. I mean, I've not obviously not as fast as I can do it, but I'm trying to do all the steps, and then, I'm just doing most of it by hearsay. So.
Okay. All right, next step is the plans.
Yes.
if you could-
What's they're supposedly done.
Right. Okay, thank you.
Okay. Thanks. Do I need to
All
leave
right,
for
I'm
anything?
going to make the following ruling. I'm going to find that the respondent is the legal owner of the property at issue and that the city has met its burden of proof in establishing that the property at issue is not in compliance with the City of Oviedo's Code of Ordinances, and the respondent shall have until Wednesday, January 22nd, to bring the property into compliance, and failure to do so will result in a fine. I didn't ask the city what its request is as to a fine. So you'll have until January 22nd to bring it into compliance, and if it's not in compliance after that, it'll be a $50 per day fine until it is brought into compliance. And I will reduce that to an order that will be mailed to you, so you'll have that in writing. And just if you can try to work on that architect. So thank you. Thank you for being here today. Exhibit A. Okay, nothing? Okay. Oh, yes, please. Are you signing on behalf of the city? Okay, sure. You can finish here. Do you usually have the department heads sign agreements like that? Okay. That's fine. Mhm. Thank you, thank you. Yep. With my best to Mr. Groot. Thanks. All right. Moving on.
Good morning again, Your Honor. My name is Sean O'Rourke, Code Enforcement Manager for the City of Oviedo. This next case, CE 13-0020000, is in regards to the property at 190 Oviedo Boulevard in the city limits of Oviedo and Seminole County, Florida. Before I go any further, Your Honor, the respondent is here and has expressed to me that they would like to request a continuance. The city doesn't have an objection, but I would allow them to make that request before I start presenting anything.
Okay, you have no objection?
No. The only stipulation I would like, Your Honor, is that there would only be one continuance to the next hearing, not repeated continuances. This needs to be addressed.
Okay.
Thank you.
And the respondent. Oh, okay. Come on up. Before you testify, could I get you to, I'm going to swear you in. If you could raise your right hand. Do you swear or affirm that the testimony you shall give shall be the truth and nothing but the truth?
Yes.
Thank you. Please, you can put your hand down. Thank you. Go ahead. Please introduce yourself and let me know what you would like me to hear.
My name is Victor Blair, pastor Fountainette Church, and we're simply asking for a continuance. We've had some problems, obviously, with the contractor, and so I'll just have to fix this.
Right.
And so we can get a continuance. I'll get it taken care of before the next hearing.
Okay, the next, you might have heard, the next hearing is January 23rd, so how about a continuance until January 22nd?
That's fine.
With the agreement that we won't have another continuance following that.
That's fine.
Okay.
Thank you.
And that's all good. Thanks for being here.
Okay.
Good morning.
New face. Oh, yes, please.
All right. Good
Yes.
morning, Your Honor.
Good morning.
I'm Monica Cole, Code Enforcement Officer for the City of Oviedo, and this is case CE 13-001537, which is 1066 Glen Circle, which is in the city limits of Oviedo in Seminole County. This is for violations of Article 4, Property Maintenance Code, Section 14.70, adopted by reference, specifically Section 304.1, 304.15, and Section 505.1, for not maintaining the exterior garage door in good condition, specifically a missing garage door, and not properly connecting the household plumbing to a public water system or an approved private water system. All evidence will be presented in chronological order. All statutory requirements have been met for this hearing. I do have a packet of evidence for Your Honor that I would like to ask be Exhibit A, if I may approach.
Any objection? Hearing none, this will be the city's composite Exhibit A.
All right. So on July 23rd of 2013, I received a complaint that they were missing their garage door and that they were connected to their neighbor for obtaining their water. So I went out and did an inspection and did observe that there was no garage door present on the structure, and there is a hose running from the neighbor's house to the respondent's house. So I went back to City Hall and I researched the water records, got with the utility department. There has not been water on this property for over a year now. In fact, the water department has filed a lien on this property as well. So on July 29th, 2013, I went back out to the property and left a business card requesting that the respondent call the office. The respondent called the office on the same day and spoke with Mr. O'Rourke, the code enforcement manager, advised that he had had some financial and legal difficulties and didn't really think that he was going to be able to do anything. So Sean gave him a little more time, asking him to try to, like I said, try to get the garage door replaced and get the water turned on. On August 14th, 2013, I re-inspected and we still had no garage door. The water was still connected to the neighbor and no new account had been applied for. On August 15th of 2013, I sent a notice of violation to the property owner. That's the next page in your packet there. That was returned unclaimed. So on September 4th of 2013, I did a second notice of violation. And then you have the affidavit of service where I posted that property on September 4th, 2013. I apologize. Officer Orioles posted that property on September 4th of 2013. We posted City Hall and mailed first class, therefore achieving service for that notice. On September 20th of 2013, I re-inspected. There's still no garage door. The property was still hooked up to the neighbor's water. At that point, I did an affidavit of violation and a request for hearing, along with the notice of hearing, and that was mailed certified to the property owner. Again, that was returned unclaimed. So on October 23rd, I re-inspected again. We still had the same violations. On October 24th, we prepared, again, the affidavit of violation and the request for hearing for today's date, and posted that on the property. Again, you see the affidavit of service that we did achieve service for this hearing. Next, you have pictures that I took today. Still, there is no garage door. And then you can see the hose that's connected between the properties. I also had the utilities department print some of do some screenshots. You can see that there has been no consumption for an account at that address since, it goes way back. We have zero consumption. It looks like since 12 of 2012, and it dropped drastically in November of 2012. The last page there is the work order showing that the meter is off and locked, and that was done on November 1st of 2012. So we have the chronological history from the initial inspection to today's date. It has been 143 days. Since that initial contact that the property owner called in and spoke with our manager, we have not had any further contact with the property owner.
Okay, and what is the fine that the city is requesting?
With $50 a day beginning on January 23rd. So give them until January 22nd for the next hearing.
Okay, and there's no one here to speak on behalf of
No, ma'am.
All right. Then, having heard the testimony and considered all of the evidence, I find that the respondent is the legal owner of the property at issue, that the city has met its burden in establishing that the property at issue is not in compliance with the city of Oviedo's ordinances, and the respondent shall have until January 22nd, 2014, to bring the property into compliance, and failure to do so will result in a fine of $50 per day for each day that the property remains in compliance. And I will reduce that to an order.
Thank you, Your Honor.
$50 was generous. I hope they can get it fixed. Water's important.
They do have water, like I said.
Well. Okay, I don't see anything else on the agenda.